Hello, good night. Welcome to Legalize this 24th day of November 2024. On 22nd October 2024, the Caribbean Court of Justice, the CCJ, delivered a decision in the matter of Ellis Richards and others versus the state of Trinidad and Tobago. The claim was brought on behalf of British American policyholders in Grenada and Antigua-Barbuda who suffered loss and who sought compensation from the government of Trinidad and Tobago for their losses. The claimants had formed themselves into an organization called BACOL. The matter was prosecuted on behalf of BACOL by a team of lawyers from the UK and the Caribbean. Dr. Antoine, the former Prime Minister of St. Lucia, was a member of the team of lawyers. Ms. Benz was a consultant to the team of lawyers, and Dr. Partick Antoine is the president of BACOL. Unfortunately, Dr. Antoine cannot be present with us tonight. He was committed to being here, but is seriously under the weather. However, we have Dr. Antoine live. The contribution from Ms. Smith was pre-recorded. And of course, I have here my co-host. I have my co-host, Jomo Thomas from St. Vincent. Good night, Dr. Anthony. Good night, Jomo.
Good night to be here.
Let's follow this program.
Delighted.
Before we go in,
good night to Jomo as well, and of course to all your listeners in Grenada and throughout the region.
Yes, before we go into the program, however, I would just like to recognize the sponsors of this program, Gel Professional Solutions, Inc., Gem FM carrying this program on FM radio out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Okay, I'm told that I said Dr. Anthony will not be here, but it's Dr. Antoine who is not here with us. So I just want to make that correction. So as I mentioned, the contribution from Ms. Benz was pre-recorded. I don't think that there is any need to introduce Dr. Anthony. He's well known in these parts as former Prime Minister of St. Lucia. And likewise, Brother Jomo is also is a regular on this program and well known in these parts. Also, he told me he had visited Grenada on 55 occasions, so he's known in Grenada. Ms. Benz, however, is unknown, but she was a consultant to the team that carried the matter, and as part of the pre-recording, I have Ms. Benz introduce herself. I think there's a problem with the audio. I admit there's a problem with the audio. We're not hearing anything at all. We're not hearing anything. We're not hearing the audio. There's no sound is coming through.
I'm a competition lawyer, and my firm, Men's SRL, for the past 15 years has been doing trade regulation law, regional integration law, single market law, common market law. And as part of this broad body of work that we do for African and Caribbean countries, we had been doing the development of a financial consumer protection law for a model law for the CARICOM member states. And I think that drew the attention of the client. And we agreed to bring on one of our barristers and to work on the case. And yep, that's where we joined in.
Yes, so that's Miss Benz. She is based all the way out in Europe. She is not able to be live because she's 6 hours ahead of us. So it's now early morning where she resides, and due to family commitments, and so she's not able to be here. But to set the background to set the context for tonight's discussion, we will hear from Ms. Benz just a few minutes again as she puts this matter into a perspective. And then, of course, we will go over to Dr. Anthony, who will help us to address issues arising in that matter, which, of course, is of great interest and importance to people in the Caribbean, in particular the small islands, and in particular Grenada and Antigua. Because the outcome that we all hope for was not arrived at in the case. But for persons, people watching the program, I know people in Grenada have expressed a lack of understanding of what the case is really about and how the case ended up in Trinidad, how it happened that people from Grenada and Antigua, which are independent countries as Trinidad is, how it happened that we, Grenadians and Antiguans, and other people from the OECS could be taking Trinidad to port and doing so in Trinidad. I don't know if you can just explain a bit of that, how that came about.
Well, generally speaking, under the revised Treaty of Chaguaramas, individuals, meaning natural persons, and legal persons, such as business entities,
If I may ask, not to interrupt, but we speak into the uninitiated, so the Treaty of Chaguaramas is?
Sorry. So the revised Treaty of Chaguaramas is essentially a treaty that allows for the free movement, where all the CARICOM member states, not all, the ones who have signed up to the CARICOM single market and economy, have agreed to the free movement of persons, goods, and services. And when we say free movement, it's almost as though they want, not almost, it is as though they want to create an amalgam, a union, a combined or aggregated market space, which is made up of all the Caribbean countries or the CARICOM countries that have signed up to the revised Treaty of Chaguaramas, ratified it, incorporated it into domestic law. So it means that all the businesses, all the consumers, all the market players across every single industry would form part of one single market, which is the CARICOM single market. So it's almost as if you're going to a market, and in that market you have Grenada, Barbados, St. Lucia, Jamaica, Guyana, Suriname, and all of these countries are players. The member states, if they're engaged in economic activity, the companies that are registered in the member states, if they're engaged in economic activity for profit, the consumers in the member states, if they are buying and selling and trading in that space. And whether or not it is a good or a service, it is part of that member state. And as such, that amalgam, that complete union, that big market space that we've created by the terms of the treaty are subject to all the various rules of the treaty, including a rule that says the Caribbean Court of Justice has jurisdiction, original jurisdiction, to interpret any dispute arising out of that single market and economy treaty.
Okay, so it is a special arrangement between CARICOM member states that you say basically for the purposes of trade, they have almost decided as though we will operate as one country.
And we will operate as one market.
As one market.
Market, which is key.
Mm-hmm.
One market. And
Yes.
as a dispute, as a final arbiter of disputes originating in that market, the Caribbean Court of Justice. There are other institutions that can help to resolve disputes. There are other institutions that can create rules governing the market, but it is the Caribbean Court of Justice that will resolve disputes between individuals, because individuals have standing. It's a trade treaty, so individuals who are buying and selling have standing before the Caribbean Court of Justice, who is the final arbiter of that market. Cases involving individuals and legal entities. So me versus a company. Cases involving two member states, Trinidad versus Antigua. Cases involving individuals such as a legal entity, a Trinidad Cement or CLICO or any of the banks from any of the jurisdiction, any institution against a member state or any consumer association against a member state. So it's a market, and so any market player, as long as they're engaged in economic activity, such as trading goods or services, are able to seek resolution of a dispute that arises by the terms of the treaty before the Caribbean Court of Justice.
Okay, good. So in this particular case, therefore, what happened is that people from Grenada, Antigua, and other countries, they had a dispute, they had a grievance, they considered they had a case against Trinidad. That's right?
In this dispute, a number of things happened. We had a big conglomerate operating on a cross-border basis. And that's the trigger, and that's the key for when the market, the single market, comes to the fore. So we had a company, a conglomerate, that traded or operated financial services on a cross-border basis. It had customers in Trinidad, it had customers in Grenada, customers in Antigua, and other Eastern Caribbean countries, and also in the Bahamas too. So it operated across the region. And therefore, any of the countries that have signed and ratified the revised Treaty of Chaguaramas, if it operates services or selling in or into any of these countries, it naturally triggers the treaty. So this company CLF Group goes bankrupt.
Mm-hmm.
Because it operated through its subsidiaries or conglomerates, one of them being BA International, and BA International sold various pension and insurance schemes to customers in the single market, which would obviously include Grenadian consumers, Grenadian pension holders, Grenadian insurance policy holders, Antiguan policy holders. It means that when that company goes bankrupt, there now arises a series of disputes. How can I get back my money as a policyholder originating in Trinidad, or as a policyholder originating in Antigua, or as a policyholder originating in Grenada? Now, the government of Trinidad and Tobago, recognizing that the bankruptcy and the insolvency or the lack of resolution of this major financial upheaval could compromise significantly its economic situation and the stability of its economy, decided that it was going to dive into the fore and bail out this conglomerate. It triggered its Central Bank Act, a domestic legislation, and by triggering that domestic legislation, it issued certain mandates that the central bank was to take over this failing institutions, buy up its shares, do a number of other things to, in other words, to sort of like harvest the leftovers of the shares, the assets, and bring it into the central bank as though Trinidad owns it. And to use the proceeds of the conglomerate, including BA International, which had customers in Antigua and Trinidad and assets in Antigua and Trinidad and Grenada, and use all of that asset for the benefit of bailing out the Trinidad policyholders and a few Eastern Caribbean policyholders. But key is that many policyholders in Antigua and Grenada were not comparably compensated, one, or two, were never compensated at all. And when we say comparably compensated, we're using as a comparator the Trinidad and Tobago policyholders. And it is that essentially the government of Trinidad and Tobago, we alleged in the case, triggered a resolution arrangement where it took all of CLF's subsidiary assets and used it, expropriated it for the benefit of enriching the Trinidadian government and compensating and reimbursing Trinidadian policyholders to the exclusion of certain policyholders in Grenada and Antigua.
Yes. Doc?
Hi.
Yes, yes. Well, maybe you can take off from there.
Well, as I said earlier, I just want to extend greetings to all your listeners in Grenada and across the region. I am certain that most of your, if not all of your policyholders are deeply disappointed and I would say devastated by the decision of the Caribbean Court of Justice in this matter. The expectations were high, and I think it is true to say that the lawyers who participated in representing the policyholders were themselves very deeply distressed by the outcome of the case, and in particular by the reasoning of the Caribbean Court of Justice and the conclusions at which it arrived. I believe that it is a judgment that will attract a lot of commentary in the years ahead. it will be analyzed and reanalyzed and re-examined and examined. But at the end of the day, I also believe that the judgment probably signals the need to revisit the architecture, the legal architecture that was established to determine disputes arising from the treaty, as your colleague Menz explained a few moments ago. But we can come to that later on. You may want to now go into some aspects of the judgment, and I'm happy to provide whatever support that I can to help you to do so.
Yes.
But certainly, it was a devastating decision.
Yes, because the thing about it, I think this judgment is described as the judgment in Ellis Richards number 2.
Yes.
Right. Why number 2?
Okay. When we first filed the case, there were certain preliminary issues that arose. The government of Trinidad and Tobago argued at the very outset that the exercise of the power by the government of Trinidad and Tobago did not fall for scrutiny under the treaty provisions, that in fact, the treaty protected the exercise of the powers of the government of Trinidad and Tobago, in that what it did was that it had a specific provision that allowed the government of Trinidad and Tobago, in cases such as occurred in Trinidad, to take the actions that it did, and that therefore the actions of the government of Trinidad and Tobago could not properly fall to be scrutinized by the court in respect of certain specific provisions of the treaty. In other words, that it was a legitimate exercise of the power of the government of Trinidad and Tobago in a period of crisis. Now, this was described as Richards number 1 because it was a procedural point, and the court wanted to determine whether a decision on that procedural point would have the effect of rendering it unnecessary to consider the case in its entirety. In the event, the court decided that while the exercise of the power of the government of Trinidad and Tobago, specifically because it was protected by what we call Article 30, Sub-Article 2 of the treaty, it did not really have the effect of completely knocking out the arguments of the policyholders, but there were still other issues that had to be resolved. Whether, for example, an argument could be maintained for discrimination contrary to Article 7 of the treaty, or whether there was adequate redress for the policyholders who, under the treaty, would have been consumers. So those matters would proceed. In fact, to put it very simply, in Richards number 1 and the state of Trinidad and Tobago, the court dismissed the claim that Trinidad had committed breaches of Articles 36, 37, 38, and Article 7 of the revised Treaty of Chaguaramas that was explained to you earlier on. The court held that the interventions were properly within the exception, as I explained, provided for in Article 30 Sub-Article 2. That is, activities in a member state involving the exercise of a governmental authority. In other words, the actions were actions properly falling within that exception of Article 32, and therefore could not be brought to judicial scrutiny. Now, it was a very significant decision because I think in Richard number 2, which is the substantive case that dealt with the issue of whether there was discrimination or whether there was adequate redress, which we can come to in a few minutes, the court found itself in an intellectual cul-de-sac. In fact, when I went through the judgment, to be honest with you, I said to myself, but really bother dealing with the subsequent arguments, because when you read through the judgment, I cited at least 4 occasions when the court in number 2 anchored itself on the decision that it had made in respect of Richard's number 1, and it is really intriguing how often the court said, well, it had decided this in number 1, and therefore it will not revisit to change its position in respect of number 2. So in effect, what we have here is almost as if we are in a situation where the court virtually predetermined its own logic, and its own logic led it to a situation to look at, for example, what I'm talking about, paragraph 143. You may want to look at paragraph 159, I think it is, in the judgment, that you'll understand what I'm getting at. So it was really very, very unfortunate because the court could not extricate itself and unburden itself by its own logic and reasoning in, of course, Richard's number 1. And I think that caused immense problems in that judgment throughout.
So Richard number 1 was really a body blow to the matter.
It was really a body blow, given the frequency with which the court resorted to reflecting on invoking, Richard's number 1.
Yeah, I want to ask this question. If Richard's 1 was decided, would Richard's 1 not be precedent upon which the court can rely?
Jomo, you would have to say that again.
If Richard's 1 became precedent, would Richard's 1 not be a case upon which the court can rely?
What he's asking is that if Richard's 1 was a precedent, if legally Richard's 1 was not something that the court could rely on in Richard's 2. We have some internet problems, but if I may say, Dr. Anthony?
Yes, Yes, and the court was at pains to give a lesson in why it was bound by its previous decisions, because other decisions were invoked. In fact, at one point, the claimants did suggest to the court that they might want to revisit a judgment. That is the judgment in the Douglas case coming out of Dominica. Mm-hmm. And the court said, well, listen, we're not going there because there are specific, there's a big difference in this treaty, and this treaty virtually compels us to be bound by previous decisions. Now, but the reality is, and my argument is this, if you look, as I said, like paragraph 119, if you look at paragraph 159, if you look at paragraph 129, all of those paragraphs in the judgment, what you see is that the court is constantly hammering the decision in Richard's number 1. And strictly speaking, the court did not need to invoke Richard's number 1. And my point is, the reality of the situation is that, and really consider the issues that arose in number 2 with the clarity, with the independence, with the flexibility.
And if I may say,
in Richard's number 1.
Yes. Let me just ask, because I think I recall one of the complaints of the lawyers being that Richard's number 1, as they refer to it, I don't know if that is helpful, breaking it up into Richards number 1 and Richards number 2. Because some may argue that this was one matter that was before the court, that so-called Richards number 1 was a preliminary point in the same matter. And therefore, the court should have treated it that way. But that's besides the point. Right? What I want to ask is this. I've heard this argument that Trinidad was relying on an exemption in the treaty.
Correct.
Okay. An exemption ought to be, and I think the court accepted that.
That was the exemption under Article 32.
Yeah?
Article 32.
Yes.
Article 30 sub-article 2, yeah.
Right. The argument goes as an exemption ought to be strictly construed. And therefore, the court ought to have examined, by way of hearing evidence, whether Trinidad, in fact, operated within that exemption or whether they stepped outside of it. Because I think the argument was, and I think Ben's developed it in the pre-recording, that the argument was that Trinidad had engaged in commercial activities, which is what Article 3 covers, and that what Trinidad did was not, in fact, she described it as Trinidad put their hands on the scale in favor of Trinidadian companies, and that Trinidad acted commercially.
Yeah, but it goes a little further than that, because the real question is what is left of the treaty given the interpretation of Article 30 sub-article 2.
Exactly.
If a government can rely on this so-called exemption in the treaty, the question is, what other redress can you conceivably have against a government that decides purposefully that it is going to invoke Article 30 sub-article 2, the exemption to which you speak? Of course, one can argue whether the particular circumstances do allow for through the exemption per se in particular circumstances. But the fact of the matter is that a government does not really have very far to go to invoke that exemption at all. And so to a very large extent, I think the court overplayed its hand where that is concerned. But I have never quite understood myself how the court was able to distinguish the facts of the matter in Trinidad, respect of Article 32, and how it distinguished that from the decision, an earlier decision of the court in Myri's case, because the court made short shrift of the Myri's case, whereas Myri, in fact, provided a clear view of how Article 30 sub-article 2 should be interpreted, because it was invoked by Barbados in that case. So I have great difficulty with how the court was able to invoke that exemption and say that such use of governmental power is an exemption that a government can rely on and therefore find protection from any claims against it in respect of powers that are exercised pursuant to that exemption.
So the big issue that comes out in terms of your earlier point about revisiting the architecture is the issue of that exemption. Because you basically say you could I
think it's more than that for me. As someone who was involved in the move by CARICOM to go to establish the Caribbean Court of Justice, because you may recall that I was the lead Prime Minister for Justice and Governance when the court was established, and the responsibility fell to me to nurse the process, to encourage the process, to facilitate the accession to the Caribbean Court of Justice. I am beginning to think that we may have to revisit the decision-making process on the treaty itself. Because what happens is that there's only one hearing, and that is by the Caribbean. When I say one hearing, you don't have an appellate process. You do not go to a court of first instance, and on appeal you go to the Caribbean Court of Justice. You go directly to the Caribbean Court of Justice. And now what that really means is this, that the Caribbean Court of Justice is exercising what we call original jurisdiction. It is not exercising an appellate jurisdiction. It is hearing the case for the first time. It doesn't have the benefit of a previous decision to review. Now, I am not so sure that that is necessarily a good thing after this experience with the court, because part of the problem with the court is that at the hearing that we had, as you know, there was only one judge who had any serious expertise in public international law and treaty law. Only one. That has changed now. A new judge has been appointed, by the way. I think she's from Jamaica. And my understanding is that she has expertise in public international law. Now, the question is whether what should in fact happen is that trade tribunals should first be established under the treaty. Let them hear these matters first. In other words, let the matters be heard by trade experts, persons who are familiar with trade law and public international law, and then let it go on appeal to the Caribbean Court of Justice. But that, of course, some may argue will denature the treaty in the sense, Ewart, that the whole idea behind the current arrangements in the treaty, was in fact expedition, that it was thought it could not be in the interest of the business community to delay cases dealing with trade and commercial matters. Once a dispute arose, it was necessary to deal with the dispute almost immediately to have a decision. But we can see the dangers of that kind of approach, because in the case of the policymakers, I don't think the policymakers had this opportunity to at least have the matter fully aired and fully tested, because the court was not responding in an appellate capacity to a previous decision. So I think we need now to begin to look at that architecture to see whether adjustments should be made. And those of us who sat and watched the court as it deliberated in this matter, there were times when we felt that the court almost brought what we lawyers could call a common law approach to the decision-making process, whereas this is a public international law matter, and you had to put the common law aside. And you could hear the overtones, the common law overtones between our lawyers and the court as it sought to come to terms with the issue. So I don't know. I mean, I think for future architecture, we might have to revisit and have a look at it. But there are other issues with the judgment, what I think we really need to look at. I have to tell you that I was very disappointed how the court dealt with Article 184J. And if I may very quickly, because it's a very short article, you recall that 184J says, member states shall promote the interests of consumers in the community by appropriate measures that provide adequate and effective redress for consumers. And part of the argument that we had presented to the court was say, look, BACOL policyholders in the Eastern Caribbean did not get adequate redress. For one thing, Trinidad behaved in a discriminatory manner by protecting its own policymakers, but did not extend similar treatment to BACOL policyholders in the Eastern Caribbean. And therefore, there was unequal and unfair redress, that it amounted to discriminatory treatment since consumers in the Eastern Caribbean did not get adequate redress. Now, when you read the judgment of the court, you can see the court is struggling on this issue. And the court comes to the conclusion that since the article says that there ought to be appropriate measures, and since there was an absence of appropriate measures by member states of CARICOM, that they had not enacted legislation to ensure that the rights of consumers were protected. And they narrowly interpreted appropriate measures to mean legislative measures. But surely appropriate measures means more than legislative measures. And it then comes to the conclusion that in the absence of these appropriate measures, in the absence of these legislative measures, in the absence of CARICOM-wide legislation, then therefore the claimants could not rely on this clause to present the argument that they did not obtain adequate redress. Now, in the first place, in my view, if member states did not enact legislation, and the provision never says member states should enact legislation, it never says so. That's not the language. But if CARICOM member states did not enact legislation, then obviously the consumers, meaning the policyholders, should have obtained the benefit of the non-action of CARICOM states. It's not the other way around. And I really, to be honest with you, was at a total loss how the court arrived at its conclusion that in the absence of those appropriate measures, in the absence of harmonized legislation by member states of CARICOM, the policyholders could not invoke the issue of adequate redress to anchor their argument that there was unfair treatment and discriminatory treatment against them across the region.
Yes.
I'm afraid I don't see the logic. I don't understand the logic.
Doc, before Jomo, you may want to hear Ben's view on that.
Yes, maybe we go inside. I don't know.
Yes, definitely go inside. So let's get Ben's view on that issue. Sheila.
The court created, in its March decision, created room for there to be a follow-up case that the claimants could have brought on the basis of, again, discrimination, and also on the basis of Article 184(1)(j on the issue of financial consumer protection.
Yes, and what was the decision on that?
I don't want to speak to what I want to highlight, especially for the policyholders and especially for consumers going forward under the RTC, is sort of like a better understanding, which was not clear to me from the decisions reached by the court in October. A better understanding of what the financial consumer protection provisions are intended to do, and how, in my mind, they should rightly be applied. Every protocol under the treaty applies independently of each other.
Mm-hmm.
But a foundational principle of every single integration or regional integration treaty, a single market treaty, or any statute trying to grow investment in a region, grow the economy of a region, the fundamental principle is non-discrimination and leveling the playing field for businesses operating in the market. So that principle of non-discrimination is what we call foundational and generally applied to all the provisions of the RTC.
Mm-hmm.
So even though the court in March found that there was no issue of discrimination as it related to Article 36, etc., we could still go on to try to prove discrimination on other bases, under other protocols or other chapters of the treaty, which is what we did here in the second case. And so in the second case, we brought to the fore once more the principles of discrimination, which we saw in the context of Article 184(1)J and so it's Article 7, which is the principle of non-discrimination on the basis of nationality, as it applies to Article 184(1)J and their right to originate suit before the court on the basis of Article 184(1)J. And it's on that basis that this suit was brought, the second suit was brought.
Okay.
It basically says that the Antiguan and Grenadian consumers were not comparably compensated or not compensated at all versus what had happened with the Trinidadian consumers. And that's the basis of the suit. And it originates from Article 184(1)J, where there's an obligation imposed on member states to redress consumers. And we have something called the correlative rights under the treaty, meaning if an obligation is imposed on the government or a state, the opposite face of that obligation is a right as a consumer. So,
two sides of the same coin.
yes, opposite sides of the same coin. Here it is, Article 184(1)J imposes an obligation on the member states to redress consumers, and therefore I, as a consumer, have the right to seek redress. And so this is what this case was about, seeking redress and ensuring that that redress is done in a non-discriminatory way. Whatever you do for the Trinidadian policyholders, you should have done for me.
And the court decided what? Because the facts show that Trinidadians were treated differently from policyholders from Grenada and Antigua. So how did the court treat with that obligation under Article 184?
I think the thing that sticks in my mind about the court's decision is that the court found that the member states could not have countenanced that there's an obligation on CARICOM member states who are party to the CSME agreement, could not have countenanced that the court would impose an obligation on a Trinidad government to compensate St. Lucian or Grenadian or Jamaican or any consumers but Trinidadian consumers. And it's so glaring for me that decision itself is so inimical to any objective of the growth of a single market. But that is essentially the outcome of the court's decision.
I think the court also said that those sections were just aspirational, and basically there was nothing specific to under that section.
To that, if in 2024, let's remember that the revised Treaty of Chaguaramas was from 1993, and what or West Indian Federation. We aspired to it since 1945, I believe. And in fact, the EU copied their single market from what or great leaders in 1940s created. And we are still talking about aspiration.
Collapse in 60.
Yeah, so here we are in 2024 still saying that provisions that have been ratified and enacted under Caribbean Community in Cooperation legislation are aspirational. And we have to remember that treaties do not have an exhaustive list of protocols and implementing regulations. That is not how treaties are made. That is not even how legislation is made at the domestic level. In fact, when we pass legislation at the domestic level, we give ministers the right to make secondary or subsidiary legislation and notices and guidelines and to create institutions. And the treaty does the same. And no legislation is static, not even constitutions are static. And here it is, we have committed to an evolving system And it must be an evolving and dynamic system, because how else can you grow a single market? But to keep incorporating laws, to keep making different public administrative decisions, to keep coming up with guidelines and rules, to keep changing the institutions as the market grows. There is no way anyone under 2024 can think of a treaty as a static aspirational instrument that would not depend on subsidiary lawmaking, whether it's through COTED, whether it's through whatever institutions, to create subsidiary laws to make it workable. But not just that. I'm for black and white, black letter, common law legal system understanding of law. So when you write a treaty and you sign the treaty and you copy and paste the contents of the treaty and you enact it in the domestic parliament, it is law.
So that's
Yeah.
Ben's view.
I know we don't have much time, though, and Jomo, I don't mean to keep you out of this discussion, but there's something else I think I really need to mention just before we conclude. I have to tell you that
we go to 8:30 now. You have to leave already? Yes.
No, it's okay.
Okay.
Well, in that event, I'm just going to proceed with my point.
What's it tell us?
One of the things that I found was that the court displayed what I describe as excessive sympathy to Trinidad and Tobago. And I want to just draw your attention to two paragraphs in that judgment. Paragraphs 154 and 155. Now, you tell me whether this paragraph makes any sense to you, and whether that is a sound legal reason to justify the differences in treatment meted out to policyholders in Trinidad and policyholders in Eastern Caribbean. Listen to what the court said. And I'm going to just read out paragraph 155. As to whether there was an objective and reasonable justification for the difference in treatment, it is undisputed that should the claimant's arguments be correct, that is the policyholder's arguments, it would have meant that the defendant would have been responsible, meaning Trinidad and Tobago, for bailing out all the policyholders, not only in Antigua and Barbuda and in Grenada, but all those BACOL policyholders from other territories in the Caribbean where BACOL policies were sold. According to the opinion on recognition of foreign proceedings annexed to the witness statement of Jean Green Thompson, BACOL has had branch operations in 14 jurisdictions: Anguilla, Antigua and Barbuda, Bermuda, the Cayman Islands, Curacao, Dominica, Grenada, Guyana, Montserrat, Panama, St. Kitts and Nevis, St. Lucia, St. Vincent and the Grenadines, and the Turks and Caicos Islands. BACOL also operated through subsidiaries in further 5 territories: Aruba, Barbados, the British Virgin Islands, Curacao, and Trinidad and Tobago. Now, these are the key words. It could not have been within the contemplation of the framers of the revised Treaty of Chaguaramas that the member state in such circumstances. No. What is the legal basis of that? What on earth does conclusions, the discriminatory treatment against BACOL policyholders holding their policies in the Eastern Caribbean, then the question of how they are compensated is a matter to be settled between the defendant and the claimants, but doesn't have to do with the integrity of the legal process, the legal reasoning that is vital to determining the case. But what the court is saying here is this: if Trinidad is faced with this problem of having to compensate 14 countries, it could not have been within their contemplation or within the terms of the treaty that they be so compensated. I mean, what basically is a legal justification for that kind of argument? And no court should have been invoking that kind of argument in a matter like this. That is why I say, for my part, I found that in the process, and don't get me wrong, I am not casting any aspersions on the court. I'm not. All I am saying is that that certainly cannot be a legal argument for the court to buttress its conclusions. And no court really should have resorted to such an argument to justify its conclusions.
Were you surprised that there were no dissenting opinions in this decision?
So
I didn't hear you.
Were you surprised that there were no dissenting opinions on this decision?
I was. Frankly, I was. I thought that we might have got at least one dissenting opinion. I think the court seemed to have gone to tremendous effort to have had a unanimous decision. I must say, and I give the court credit, they were very careful to lay out the facts of the case. In fact, the judgment was consumed basically, or most of it really was consumed with the actual factual background. And the court did a reasonable job. I have problems, however, though, I have to confess. And I invite all of you to take a look at how the courts treated the evidence of the evidence of the witnesses for the claimants. And if you look at those witness statements, particularly paragraphs down from 65 to 71, I don't think the court did justice to those witness statements at all. It seemed to me that what the court did was to pluck out those little points in the witness statements that somehow bolstered the argument that, look, there was no rational basis to come to any conclusion of discriminatory treatment or an absence of adequate redress. And the court seemed to have ignored, for example, the other evidence dealing, for example, the extent to which assets of BAT and BACOL was commingled. And if you notice, the court paid very little attention to the issue that BAT in Trinidad and Tobago, in fact, virtually managed BACOL. They made short shrift of it, so that a key linchpin of the entire case was totally destroyed, in my view.
Yes. Jomo, you're looking to say something again? I just want to take some comments.
Good.
Yeah, I just want to take some comments. Dr. Anthony, I said you are well known in these parts, and I know you are well known, but someone is asking me here, is Dr. Anthony a lawyer? So I responded, his PhD is in law, and he was once counsel for CLICO. So that's what. Then
Thank you.
Someone is saying that, well, someone who said that they have always had concerns about the Caribbean Court of Justice and joined the contracts with the Privy Council and essentially saying many of us who oppose the CCJ during the constitutional reform for Grenada was precisely out of fear of a lack of confidence that Caribbean leaders would want to interfere to tip the scales in their favor. I don't think you're saying that.
No, I'm a firm believer in the Caribbean Court of Justice.
Yes, and I am also.
I believe in the quality of in judgments, and as an academic and practitioner, there will be moments when I disagree with a judgment, and it's not the first time that I've disagreed with a judgment from the CCJ. In much the same way I've disagreed with judgments from the Privy Council on a number of occasions. So I don't think that is the issue here at all. I do believe, however, that in this particular case, that the court may not have had it right, and I'm not too sure that the court had approached the issue correctly, and I was distressed by the mode of reasoning employed in the case. But that doesn't mean that I have any arguments against the Caribbean Court of Justice. So the court falls in disfavor. No, not at all. All courts make mistakes, and I think this is one occasion where I disagree with a particular judgment.
Yes, but the person was commented also on your point about the architecture. The court in its treaty jurisdiction being both original and final.
Yeah.
They were saying that Benz, it was in her pre-recording, took the view that, to reach on the Caribbean Court of Justice, and the justices must be learned. But your point, they may not be learned in the area of treaty law. That was a disadvantage.
Yeah, this is my point, and I also believe that there is an argument for saying that these treaty matters could have such serious implications that to allow only one judgment to emerge from a dispute on the treaty may not be necessarily fair to the contending parties or to the wider public. It is true, there is the overriding interest to ensure that there is a swift conclusion for commercial matters. There's some merit in that argument, but equally, I think a court can have the benefit of a previous judgment before it makes a final determination. And perhaps the approach might be to create a system of trade tribunals to hear cases initially coming out of the treaty, and then from there move on to appeal to the Caribbean Court of Justice.
Yes. So I just want to take a pause just to recognize the sponsors of the program, GEM, Professional Solutions, GEM FM carrying this program on FM out of Canada, and Grenada Technical and Allied Workers Union.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
I just want to say also that as we return, Chief Justice Saunders, about 3 weeks ago, was on this very program, and he was asked the question about the judgment, dissenting judgments, and so. He said that in the appellate jurisdiction there is a lot of that, but he said that there is a policy decision that they have adopted that when they are dealing with matters in the original jurisdiction, trade matters, matters that could be between state and so on, that they have a policy decision to render only one judgment. He said maybe, he can understand there may be views for and against that, but that's the policy decision. So it was a policy decision to basically, I would say, based on what he said, to rule by consensus in this matter.
To be honest with you, I wasn't aware of that. That's very new to me. But whether it's a good practice is worthy of some debate. Yeah, Jomo, you're saying.
Yes, I was going to ask, this claim, the claimants in this claim were from Antigua and Grenada. Are we to understand, is it possible for claimants from other CARICOM countries to bring a claim, or does this decision close out any such assault on what had happened?
Well, I think effectively this decision speaks for the entire region. Even if it was brought by policyholders initially in Antigua and Grenada, the court was also aware that there were other policyholders on whose behalf the claimants brought the action. So that while Grenada and Antigua were the named claimants, but basically this was an action brought on behalf of policyholders from across the region. And certainly the decision would be precedent right across the board for the entire region, for the entire CARICOM, all member states of the Caribbean community. So there's no possibility, in my view, of bringing any action from the other jurisdictions at this stage. It's a closed matter.
Let me just add that, because I think you may want to highlight that St. Lucia had a different experience in this entire process. Because some people have been saying, have been asking whether, and if so, to what extent are the individual governments liable in this matter for the losses of the policyholders.
I've heard that argument before, and in fact, if you recall, when the matter was heard, the attorney representing the government of Trinidad and Tobago actually proceeded to cast blame on the regulators in the other islands. The attorney suggested that the regulators in these islands were responsible to what occurred with the policies that are in dispute. And it is not really for Trinidad and Tobago to take blame wholly and solely that regulators in every island had to bear some kind of responsibility. But you alluded to St. Lucia, and I'll tell you why St. Lucia was slightly different, because the problem also existed in St. Lucia, particularly with the flexible annuity policies that were in issue as well. So policyholders in St. Lucia were also seriously affected. But where St. Lucia was slightly different had to do with two things. One, CLICO out of Barbados had invested very heavily in St. Lucia. They had acquired a lot of property in St. Lucia, high-end property, as well as other property for real estate, etc. So that the regulators in St. Lucia were able to latch on to those properties to get redress for consumers in St. Lucia. The second thing was this. The regulator in St. Lucia was more insistent that CLICO that CLICO be held responsible for the shortfalls that existed in the insurance in its insurance portfolio. As you know, all of these insurance companies are required to make certain deposits with the state to protect consumers. When it was very clear that CLICO was not sufficiently liquid to actually make financial deposits, the regulator in St. Lucia levied on CLICO's property, and in fact got judicial hypothecs registered against CLICO in respect of those properties. So they were then in a better position to proceed against CLICO's properties in St. Lucia. That's why it was very, very different. A lot of people, for example, did not know that CLICO actually owned a distillery here in St. Lucia. And that provided a lot of opportunity to obtain some kind of redress as well. So the situation was different because of the very, very strong investment portfolio which CLICO had here in St. Lucia.
Okay.
I thought that all of the countries had to put in place regulations that would protect their own people. And I think the way I understood Ewart's question was because they failed to do that, and because the redress, you were saying that the redress is completely closed out now at the CCJ level, but policyholders in the independent countries, each independent countries can bring a claim against their government that they didn't properly protect them in having the particular regulations in place.
Yeah, I can hardly hear Jomo because I think they...
What he said is that he was of the view that each country, each independent country under the Insurance Act had an obligation to have a secondary fund or whatever it is to offer protection to their own citizens. And he's saying that if that is so, he's of the view that there would have been a basis for action against the individual governments for their failure. In addition to any action that is brought against the government of Trinidad and Tobago.
Well, I mean, I don't know to what extent that would have been possible, because in any event, while those insurance companies were required to make deposits to the state to deal with issues of potential liability, certainly the deposits they would have made would be nowhere close to the value of the insurance policies that were so that if there was an argument there, I would imagine that the financial redress would be exceedingly limited. And in any event, the fact of the matter is that even if those deposits were made, the harsh reality is that a lot of those, the premiums for those policies left the respective jurisdictions, left the respective countries. I don't know. It is not a matter that I have given any serious thought to, but I would imagine that there would be some complications, some issues if that route was pursued.
Yes. Doc, I know there was an issue in that the government of Trinidad and Tobago at one point had promised to provide $100 million US.
Correct.
Yeah, and only a percentage of that was provided.
I think it's about 40 million.
Yes. Is there any relevance to that failure with regard to this matter?
Personally, I believe there is hope there, and there is a possibility. You see, but it will be for the member states to act on this, not really the policyholders.
Okay.
Because the decision by Trinidad to make $100 million available was a decision made at a heads of government meeting. Trinidad bound itself to make $100 million available. It was a recorded decision. And Trinidad acted on the decision by making an advance of the 40 million. In my view, there is room, there is scope for a member state to file an action against the government of Trinidad and Tobago for a determination that it is liable to pay the balance of the 60 billion because it was a CARICOM decision. It was not a decision where Trinidad had a discretionary power. Trinidad had said that it would make $100 million available. And in fact, the former government of Trinidad did proceed to make that 40 million. But it is a matter for the governments of the region to decide whether they wish to pursue. I don't know to what extent the CLICO decision would be deja vu for many of the governments. They might just well feel that, look, given the outcome of the case before the Caribbean Court of Justice, then they don't want to go through another cycle of disappointment and despondency, and therefore they prefer to leave it alone. But very definitely, my personal view is that there is a legal argument to pursue here.
Jomo?
Yes. Question, Dr. Anthony. Do you think that this decision would have any implication at all for the forward movements toward the consummation of the CSME?
If you believe that this decision will have any impact, effect on the consummation of the CSME, as you put it.
Yes, it would. Jomo, I would go as far as to say that nearly every decision of the court has implications for the single market and economy, and for the Treaty of Chaguaramas as a whole. Because, in a sense, what the decisions of the court seek to do is to explain provisions of the treaty, both in respect of the actual rights it confers, as well as what you heard earlier on, the correlative rights arising from the treaty. But I believe that this particular case will resonate precisely because most governments would be concerned about the interpretation assigned to Article 30, Sub-Article 2 of the treaty. That is the provision we discussed earlier, where the court actually said the government of Trinidad and Tobago was protected by Article 30, Sub-Article 2, when it exercised the powers that it did, because those were powers pursuant to a governmental activity. Now, I think some governments would be surprised that a member state would itself have such immense powers, that they would be surprised that they have these powers. I don't think they ever understood that they had these powers. All of a sudden, what the Caribbean Court of Justice has done is to say to them, you're clothed with an immense power. If you're going through economic distress, or you're going through a period of economic contraction, and you take certain actions to protect your nationals, then if it can't fall within Article 30, Sub-Article 2, and therefore protect you from any subsequent suit. Now, I think this is an immense power, and some governments may want to reflect on the full extent of that power. The second thing is this, is Article 184J dealing with the issue of redress. Now, I made a point earlier on that I really am at a loss to understand where the court was going with its arguments. And I said earlier on that I did not think that the court interpreted Article 184J correctly. And in any event, even if there had been no harmonized legislation by member state, the policyholders should not have been punished. If anything, they ought to have been given the benefit of the doubt, because clearly it is not their fault or responsibility that there was no legislation on the statute books to protect them. And that has really been my argument. So I don't understand the logic of the court. But given the decision of the court, some member states, therefore, might be more anxious now more than ever before to ensure that legislation exists on the statute books to protect consumers and to ensure that they get redress, especially in cross-border transactions, as will occur under the Treaty of Chaguaramas. So yes, I think it's going to have significant impact in the weeks and months ahead. And the governments, on the one hand, would be a little surprised by the new powers that they're told that they have, and on the other, there are gaps in the treaty which I think would have to be resolved.
Yes, yes. Yes, indeed, indeed. I would say I was recently I was involved in a conversation with some people from the sub-region, and they were making the point that, it is much safer now following this decision to invest in financial instruments coming out of the OECS than out of the wider CARICOM. Because the belief before that if you are in the furthest point in Jamaica or the deepest point in Guyana and everything in between, that you will be treated equally. These people are saying that that decision detonated that, and therefore the investors will be much more cautious, and investors in the sub-region, the OECS, we have our own central bank, it is OECS. People from the OECS will be much more better advised to keep their money and keep their investments here than other places, because they may find themselves to be victims of that decision coming out of the CCJ. I listened to the discussion about.
Yeah, I have a different view. I mean, we are in a single market and economy. We are supposed to invest in each other's countries. We have multinationals operating in each other's countries. And you just look at what's happening with the economy in Guyana. Guyana has taken everybody by storm. I mean, it was just today that I read the GDP. I mean, has grown threefold in the last couple of years. And the point is that Guyana beckons as a member state that has new investment possibilities. I think what has to happen is that the region has to enact new legislation to protect consumers across the region. There are limitations, I believe, in relying solely on OECS states when it comes to investment. There's only so much investment exists in these states, and we definitely have to explore other possibilities. And in fact, what is happening in recent times is that a lot of the investment in the OECS is in fact coming in to the OECS. You just have to watch what has happened with, say, a multinational like Massy stores. Massy's everywhere in the region. They're overtaking all the supermarkets. But but what I'm saying is that Massy is really enjoying the space of the OECS. It is maximizing on that space. And I always say to people that one of the interesting questions, sometimes we don't explore, we don't answer, is how much access do these companies from these other islands get to the foreign exchange of the OECS? Because as you know, we don't have restrictions in foreign exchange. You can walk into a bank and ask for foreign exchange. You don't have to go through any licensing regime. But equally, I am saying that we also have that capacity in the OECS to invest in those larger countries, and for which you would need clear mobility of funds, mobility of foreign exchange, etc. So for me, it goes back to the issue of redress, and what we should be concentrating on is creating a legal infrastructure that confer rights and obligations and protect citizens right across the board. So we don't have that kind of situation. And yes, the judgment does not help. And I think, unfortunately, in what it says, because as I was pointing out earlier in my comments, that The judgment is almost saying that the failure to enact appropriate legislation means that citizens can't get redress, and you can't rely on that to claim redress, which, as I said, don't make any sense to me at all. But I think the solution really is new legislation to protect consumers right across the region.
Yeah, I fully agree with you, but I was just making the point that that is the kind of impact that the decision has had.
Yes.
And, okay, but I just wanted to say, though, we're not going to go into it, but Guyana itself, I understand that has legislation in terms of access to its resources now and its industries and its oil, which is discriminatory. We don't have to go into it, but that's where I understand that in terms of there are certain areas which Guyanese identified by nationality, they have certain preferences over other Caribbean people.
Yeah, I mean, that may be the case, but I can also tell you that even within the OECS, there's discriminatory legislation. I mean, right here in St. Lucia, for example, I can easily identify legislation that discriminates against nationals of the Caribbean community, and you meet it in practice. You meet it in practice all the time. We have not cleansed our statute books of discriminatory legislation.
Yeah,
it's still a big issue, and the discrimination is not only sometimes within member states of the OECS, but is also between OECS nationals of OECS countries, and of course the wider Caribbean. So my point is simply that there's discriminatory legislation, perhaps in all countries, and we really have not cleansed our books. I mean, at one time, CARICOM was gung ho on ensuring that the playing field was leveled, but in recent years they've concentrated on other areas while some of those discriminatory legislation and practices still remain. So it is still a really very big issue. Very unfortunate.
For example, just to raise one last point, there is, I know honey producers in Grenada, they have a big issue in terms of some markets in the OECS, I wouldn't identify any, and also the market in Trinidad, although I think there has been some movements in Trinidad. Again, they make it the point about, well, we have CARICOM, we have CSMB, but many times they come up against these barriers and they really can't understand.
I'm aware of some of that, absolutely correct. But let me just say that your argument and your point resonates because the threshold set by the Caribbean Court of Justice to prove discrimination is a pretty high threshold. Huh? I mean, when you read the judgment, the court is setting the bar, in my view, a little high. In its understanding of what constitutes discrimination. So it's not necessarily an easy threshold.
Yeah. So we are about to end. I just want to again recognize the sponsors of the program. Gel Professional Solutions, GMFN, out of Canada carrying this program, and GTAO.
Attention all workers, your health and safety at work are critical. At Grenada Technical and Allied Workers Union, we are dedicated to ensuring you have a safe and secure work environment. If you encounter unsafe conditions or are involved in an accident, take immediate actions. Report it to the company, your shop steward, and make sure it reaches your union. Your health and safety is a priority, and a strong union means a strong voice for your rights. Don't wait. Address concerns right away and protect your well-being. For a safer workplace and a better quality of life, stand with the Grenada Technical and Allied Workers Union. Together, we can create a safer, healthier work environment for everyone.
Yes, I just want to have the closing comment that Benz gave for this program. Because I know there are many people in Grenada, they have read stories, people call me, tell me about stories, they lose everything, you know. Some people lose all their assets and they even lose their senses.
And it's unfair. It's unfair. At the very minimum, a decision should have been reached to retrieve the assets of BA International for the benefit of compensating those Grenadian and Antiguan policyholders. At the very least, it should have taken back those assets from the government of Trinidad and Tobago and say, compensate these people. You took those assets, their monies were commingled within that asset, give it back to them, at the very least.
So, Doc, your closing comments?
I think men said it very well. And a very interesting thing, is that the very comment that she made, the court accepted that that BAT did use income generated from the sale of policies in the Eastern Caribbean. The court accepted that, and yet it came to the conclusions that it did. I know that, as I said earlier on, that policyholders are devastated, but I believe that they should not give up in entirety. There is room to bring political pressure to bear on the government of Trinidad and Tobago. And I don't think OECS heads of government should give up and should avoid having to contest this issue with the government of Trinidad and Tobago. And I think political pressure ought to be brought to bear on the government of Trinidad and Tobago. I mean, the arguments are so very, very, very compelling, why Trinidad ought to have offered more redress to policyholders in the region. So I think what has to happen is that we have to shift to a new level, a different level. And the battle now really ought to be a political battle, and it is for the political leaders of OECS states to take on that battle. You have to bear in mind that there's a lot of sacrifice involved in bringing this matter. It is true that counsel representing the claimants were not paid, yet a lot of persons made sacrifices to make this possible. So that would add to this deep despondency and deep sense of loss. But I would say let's take it to another level and try to persuade the governments to engage possibly in advancing the interests of policyholders at the political level.
Yes. My co-host?
Excuse me? I just think it's interesting, because Trinidad prevails in this case. But you may recall some years ago when Kamala Prasad Desessa was PM in Trinidad, she was asked whether Trinidad would go to would relinquish the Privy Council and go with the CCJ. And I think, if my memory serves me right, her position was that on criminal matters, maybe we can go to the CCJ, but on business, international treaty matters, we should probably not do that. It would be interesting to know what her position is now, considering this decision.
Okay, well, I just want to, before we end, thank you so much, Dr. Anthony, for coming on. Jomo, thank you. Thanks to Benz. And Doc, like you said, I believe maybe the theater of operations in terms of this matter has to change from the court in terms of the immediate period to the political field.
Yeah.
So that's $64 million that is still outstanding and that there will be interest on. I think that has to be or should be pursued, and it will only be pursued if Caribbean OECS people are able to bring pressure on the government so that the government realize that it is a political issue. That's what it's all about. So thank you so much. Thank you to all the viewers. Thank you to all the listeners. Thank you to JFM. Thank you, everyone. Good night.
Thank you too. And Jomo, I'm sorry that your Wi-Fi gave you these problems. It would have been great to hear you as very
No
clearly.
problem at all. Well, I think that he was
You were having a rough night.
yes, he was really very well. So
Okay. Good night, everyone.
Good night, everyone.
Bye.
Goodbye.
Okay, nice. Bye.